Litigants seeking to avoid arbitration agreements often struggle to convince courts to refuse to enforce those agreements. When a minor applies for a job at Circuit City, he signs an agreement, but later short-circuits the store's arbitration plans, in Foss versus Circuit City stores. 17-year-old Andrew Foss applied for a job at a Circuit City in Maine using the company's online system. Before Foss could begin the application, the system required him to agree to arbitration. Later, a clause in a dispute resolution agreement required the arbitration of all claims, including federal employment discrimination claims. Foss needed to agree to continue his application. Because Foss was a minor, one of his parents needed to sign the agreement. The online system showed Foss's mother signed. Then, Circuit City gave Foss a paper copy of the agreement that only required his signature. Circuit City hired Foss. Foss complained of a hostile environment. Circuit City fired Foss, ostensibly because Foss improperly clocked in. Foss, then an adult, sued Circuit City under federal employment discrimination laws for retaliation and hostile work environment. Relying on the Federal Arbitration Act, Circuit City moved the court to stay or pause the lawsuit and force arbitration pursuant to the agreement. Foss opposed the motion, arguing the agreement was unconscionable and, because Foss was a minor at signing, void. Foss submitted affidavits showing that neither of his parents signed the agreement. A federal judge decided the motion.